Three pieces of information that you might want to know that is protected by the rules of evidence. One of the things we'll be interested to know is what you think about these three things. Number one, the amount of insurance in question. Almost every single civil trial that's brought where there is a case for negligence or carelessness, if it's a car accident, medical malpractice case, drowning case, it doesn't make a difference. There's always insurance involved, but the amount of the insurance is never disclosed to the jury. Well, why is that? Well, that's a good question. At one point in time, the idea was that if you had insurance, it meant that you were willing to engage in risky behavior. Well, that's not so anymore. So why is insurance no longer disclosed, right? Because so often, many times, plaintiffs just want to get the maximum recovery from all available insurance. What do you think? The second piece of information that is rarely shared, and that is the prior history of the defendant, of the person that's being held negligent. For example, I had a car case where the driver's license was suspended, and yet the judge did not allow that piece of evidence in. Or if they have a history of speeding, many times that's not admissible. In medical malpractice cases, it's the same thing. Almost every time we file a lawsuit against a doctor or a hospital, they've been sued at least once before, but that information is held secret from the jury. Well, why is that? Well, there's the fear that if you knew that they've done it before, that you believe that's more likely that they would do it again, and there's a belief that that is held as being unduly prejudicial. Finally, if you're dealing with a medical malpractice case, never is the history of the review by the hospital about wrongdoing brought forth. In other words, if there's a death or something that goes wrong in hospitals, they're supposed to have a review called the Mortality and Morbidity Review Committee, where they kind of go through what the hell happened. Well, their findings are never made public. They want to do that review in confidence, and they never share what the results were. Well, why is that? Well, there's idea that the hospital would engage in continually process improvement. In other words, well, we messed up because we provided too much medication. We over-medicated someone. Well, how'd that happen? Well, the syringe was too big, or someone was handling who didn't know it. And so there's a process of review for the idea of making things better, but the person, the victim, is never disclosed those outcomes. And that's the reason why almost all medical malpractice cases are brought, is to bring forth the evidence that the doctors in the MME actually review. So we're curious to know what you think about having these pieces of evidence withheld from the jury, and whether or not you think this is good, bad, fair, or otherwise. Drop us a line.